Well, welcome everybody to the Level Up Consulting Partners webinar today, which is titled CPRA Requirements for Employers, What You Need to Know. My name is Dave Cohen. I'm a director here at Level Up Consulting Partners, and I'm going to be your host for today's program. And we're going to get started with the presentation in just a minute. But before we do, I wanted to share a few program details with you. For those of you wondering about getting a copy of the slide presentation you're about to see, which is fantastic, there's a lot of good information in it. We're going to be sending out a follow-up email with both a copy of a PDF of the slides and a link to view a recording of this program following the event. So please know that you'll be getting that following. So you'll get a copy of the slides and that access to the recording. And the other thing I wanted to tell you about is that we really hope that this is an interactive discussion. This is obviously a new area, and there's a lot of open questions, a lot of gray area still to come. So we really are hoping this can be an interactive event. So please feel free to post your questions in the question and answer or chat functions here in Zoom. And we're going to try to take as many of those as we can, either during the program or more likely we've got a panel discussion section toward the end of the program, and we'll bring some in there. So let me quickly talk about the structure of the program. In just a minute, I'm going to introduce today's panelists, and then we're going to go over a brief section where we're going to talk about the scope of the law, just kind of what's covered and what falls into scope here. Then we're going to talk about some of the new obligations that are responsible organizations have under them with regards to the new CPR regulations. As we know, forthcoming, we're going to talk about that a little bit as well, as opposed to the work you've probably already done with your CCPA and prior CPRA preparations. We're going to talk about that and new privacy obligations. And then, as I mentioned a moment ago, we're going to get into a panel discussion, and that would be a good time for you to bring your questions. So with that, without any further delay, let's move on. I'd like to introduce today's panelists. So Noga Rosenthal is the Chief Privacy Officer and General Counsel over at Ampersand out of New York City. Noga, it's terrific to have you with us on the panel today. Can you tell the audience a little bit about your current position and your professional background?
Sure, and Dave, thank you so much for having me today. Again, I'm Chief Privacy Officer, General Counsel at Ampersand. Ampersand is an advertising company based in New York. Prior to that, I was at Epsilon, which Epsilon's a data marketing company, so our whole business was data. And I had 30 people helping me with GDPR compliance. So used to working with a big team. Now it's just 3 of us here at Ampersand. So I've had worn both hats. And I'm also general counsel, which also gives me another unusual viewpoint of what general counsels are facing as they try to manage privacy. And Dave, I'll start off by saying I'm unpleasantly surprised when people ask me, why should I care about privacy, even these days? And I actually think this is the #1 reason, employee data, because everybody has employee data. So anyway, that's my quick intro.
Absolutely. Yeah, no, it's great. We've got a whole spectrum of backgrounds here on the audience, I'm sure, with us. Some folks that are deeply experienced in privacy and looking for how to tweak their programs to the latest here, and also people that are relatively new to the field that are just getting into it. So that's a very good point, Noga. Thank you. And joining Noga on the panel, James Denville is an associate with Hogan Lovells. He works primarily out of the DC office. James, great to have you with us today too. And can you talk to us a little bit about your areas of expertise in your practice?
Sure thing. Thanks, Dave. And thank you everyone for joining us today. And so I'm counsel in the privacy and cybersecurity practice, Hogan Lovells. Been with the group for about 10 years. And focus on a range of general privacy, compliance, and incident response considerations. So incident response and preparedness, compliance with the various 4-letter privacy compliance frameworks, GDPR, CCPA, now CPRA, and all the others that have been arising, and also been focusing for quite some time on employee privacy issues, probably starting about 7 years ago or so, particularly with the focus on employee monitoring and the issues that arise there, but also looking at employee privacy and for US companies that were subject to GDPR, because there's been employee privacy issues broadly under that framework for quite some time. And now have been helping companies work to address the emerging privacy issues that are now in place for their US employees. So very excited to be discussing this sort of burgeoning new area of US privacy law with you all today.
Excellent. Thanks, James. So as you can see, folks out there in the audience, we've got some real depth of experience here and some interesting perspectives. So without any further delay, let's go ahead and get started with the conversation. So I'm going to turn it over to James to kick us off with the scope of the law. So James, it's yours, all yours.
Sure thing. And next slide as well. So just want to do a little bit of a high level background. And if you think I go through parts of this too fast, don't worry. We're going to dive into some of the nitty-gritty details about privacy rights requests and transparency in a little bit. But I just want to give a broad overview. I think one thing to remember with this new privacy framework is that for the most part in the US, employee privacy has been subject to maybe some sectoral considerations or really specific types of data, maybe some HIPAA data, maybe GLBA, maybe some disclosures that you might need to make around employee monitoring, like in Connecticut and Delaware and elsewhere, or some biometrics issues if you're using biometric time clocks. So employee privacy has been sort of cabined off into little verticals, so to speak. Perhaps by accident, I would say almost definitely by accident, the California privacy law, when it came across as a ballot initiative back in 2018, defined consumer as a California resident. Now, employees are California residents, so there was a recognition all of a sudden that, oh, maybe this now applies to employees. The legislature, maybe catching that they'd made a slight mistake once they enacted the CCPA, decided to employ a sunsetting provision or a carve out, essentially to punt and kick the can down the road for a little bit so that they could deal with employee privacy later. 2 years later, we're now at the point, well, 4 years later now, we're now at the point where those sunsetting provisions are going. The employee privacy provisions, the carve outs, and also for B2B data expire January 1, 2023. So this framework that has been designed in particular for consumers, in some ways, that's why it's the California Consumer Privacy Act, is now going to apply to employee data. It's always applied to employee data to a certain degree. For the past few years, you've had to provide a general notice of collection, which just tells people about the types of data you collect, how you're going to use it. And the data breach, the private right of action for data breaches has applied to the employee data. But now, effective January 1 and arguably enforceable only in July 1, if you look at the enforcement provisions in the CPRA, it appears that the new provisions are only enforceable July 1 and only for activities that take place after that date. That's when all of the CPRA will apply to employee data. So next slide, please, Dave. So who are the data subjects? Who are the people that you're worried about? Well, it's everyone that you're interacting with in the employment context. Obviously, your employees, but also your contractors, your former employees, your candidates who are applying for employment, interns, applicants, directors, beneficiaries, dependents, and the like. Essentially, all of the people that your IT security or HR teams are processing data about, they are now subject to the law. Next. And want to just take a little bit of time here. I think the initial thought is when you learn that, okay, employee privacy is now covered by CPRA, what data do we need to deal with? It's something like this: applicant information, personnel records, health records, work authorization documents, the things that you view as essential to maintaining the employment relationship. And at first glance, you may think, okay, this is going to be a little bit of work, but we'll be able to manage it. Once you start diving in, because of the broad definition of personal information, which is a very European definition, it's anything that is linkable or reasonably linkable directly or indirectly with an individual, you then see this next slide and start thinking about the personal data in this way. So it's huge, and this doesn't even cover everything, but all of the specific elements about benefits, inventory logs. Let's say that you've got, personnel who are working in warehouses and they're using inventory scanning tools, and those are tied to a unique identifier, maybe an employee ID, which is really just used for inventory tracking, maybe in rare circumstances used to track performance of an associate or employee and how well they're doing. But all of those records are now linkable to an employee. Transaction receipts at a point of sale, if you've got physical brick and mortar stores and the employees at the cashier and their employee ID is now listed on a receipt or an internal transaction record. That could be personal information. Application logs, every time somebody's logging in to a system, that could be personal information. So you may find out, and in fact, many of the organizations I'm working with find out they may have far more data about employees than they do about consumers when it comes to it, and tracking down all the places where it's stored, how it's retained, how to pull it, how to find out what it is, what it's being used for, can be a little bit of a bear.
And James, this was a real life example. So when I went to my HR department and spoke to them about what data we're collecting, they just gave me like a short list. And I was like, that doesn't sound right, guys. And when we started digging into it, that's when we realized really there is a much broader scope of what we're collecting. And it wasn't just going to HR, it was also going to the IT department because they manage a lot of our networks. And so that the point of these two slides that we just showed is you're going to have to do digging. You're going to have to talk to a bunch of people, and you're going to have to, you yourself are going to have to think through, what do we really have on employees?
Next slide, Dave. Think one of the things that has now arisen under CPRA is we have this new definition of sensitive personal information. For those of you familiar with GDPR and with California's breach rules, it's those two data sets stuck together, essentially. It's the GDPR style, European style sensitive information like trade union membership, race and ethnic origin, religious and philosophical beliefs, sexual orientation, but then add the types of information that, if breached, would trigger notification obligations in California and a lot of other states. Social security numbers, passport numbers, login credentials that are gaining access to an account, financial account information, particularly with the access codes, genetic data, health data, biometrics data, and the like. So yeah, go ahead, Noga, please.
James, the one that threw me off when I was reviewing this was login information. Why is that on here?
So I hesitate to try to explain everything that is done in the statute. However, here's why I think it is in there. They really just took the list of, if it could trigger a breach notification, it should be deemed sensitive. It's at least sensitive in the data security sense. Now, the tricky issues, we'll get into it. Sensitive personal information under CPRA, what it triggers in terms of compliance and why it's there as a concept is that you have a right to limit the use of your sensitive personal information. It doesn't do anything for data security other than there's a general, apply reasonable security. And I would think it's just intuitive that sensitive information should be protected maybe at a slightly higher level than others. But it's certainly sensitive in that you don't want login information to your apps and systems to be compromised. It is weird to think, wait, why should my employees have a right to limit the use of their login credentials? That's a weird right under California. As it turns out, and we'll get into it, there are lots of exceptions to that right. And if you're not using the information to infer characteristics about a person, it's not going to be subject to the right. However, you still need to call it sensitive. You still need to publish a privacy notice that describes it as sensitive.
And so James, so just to be clear though, for login information, right? It's not my login alone for work, right? It's login plus.
Yeah, it's the credentials that would allow access
Right.
to the account. So a username and password, username with a security question and answer, username, password, and MFA, if you hopefully got MFA for very sensitive systems. So it's that information. It's the stuff that would actually allow someone to access the account.
And again, that aligns more with data breach notification laws.
Correct.
So that actually now makes sense to me.
Yeah, and one quick note from the audience is login information was also flagged as, in quotes, sensitive information on my recent insurance policy as well. So very important to keep mind of definitions in these lists of definitions. And at this point too, it may be good to just remind the audience, James, the current legislation has, in terms of private right of action, is simply for security breach. Is that correct? And that has not changed with any of the CPRA updates. Is that right?
Correct. The CPRA, at one point, there was a push to include a private right of action. The private right of action is still cabined off for the data breaches that subject to California's traditional data breach notification law and the reasonable security. If that information is breached and it's deemed that it was breached because of a failure to implement reasonable security, there's a private right of action with minimum damages of $750 per record.
Yeah. Okay, thanks.
Next slide. There are a number of exceptions under CPRA. We're going to dive into some of them, but information that's covered by HIPAA or California's version of HIPAA, the Confidentiality of Medical Information Act, some of which is going to be collected potentially in the employment context, particularly if you've got a self-funded health plan. GLBA information, so certain benefits, ERISA plans and the like, those may be subject to GLBA carve-out, so you may not have to address compliance there. FCRA, so the background check information, there's a carve-out for that. Publicly available information, this means government records, widely distributed media, or information that an individual published with the intention to make it public. So public social media would be the type of information that would be considered publicly available and not subject to the law. Under CCPA, publicly available meant made available by government records subject to the terms of use that were applicable there. It's now broader, effective 2023. So that provides a little more room to collect and use some information. And some other exceptions that may apply, and there are more than these, but these are the ones that I think are core and key to assessing HR data compliance obligations, are whether if the obligations fulfilling them under CPR would violate other laws. So that's a deletion issue. If you have to maintain something, then you don't have to accept the request to delete. If compliance would adversely impact other people, other natural people, if it would restrict your ability to exercise or defend legal claims, the AG has not taken the opportunity to explain exactly what that's supposed to mean yet, although people have asked them for it, but there's room to push that definition. And finally, there's trade secret protections potentially. The statute effectively says the AG, or now the California Privacy Protection Agency, the CPPA, are supposed to issue regulations stating how trade secrets impact the rights that they have, but they haven't done so yet. But there arguably is room to rely on trade secrets as an exception for complying with certain issues under CPRA. Next slide. So now we're going to take a look at what some of the obligations are under CPRA, and doing it really from a lens of the employee focus. So may assume at least some familiarity with these obligations, at least on the consumer facing side. So the basic obligations here are just notice, there's the opt-out rights, there's rights to restrict the uses of sensitive PI, which we'll get into, and then it's similar GDPR European privacy rights that individuals have. I've got a right to correct, a right to access, a right to delete, and the general business obligation, which is now kicking in for employee data, but also more broadly for consumer data with the other state laws, which is fairly new in the US, although the FTC has been pushing it for a while, is data minimization and purpose limitation. So only collect the data that you need to achieve specific purposes, and only keep it for as long as you need in order to achieve those purposes. Notice. So there are effectively three types of notice that are required under CPRA. One is the notice of collection, which is just a general, here's what we collect, here's how we use it, here's how we sell it, which probably doesn't happen that much in the employee context. Here's how we quote unquote share it, which is targeted advertising, which probably doesn't happen that much in the employment context. But now you also have to add information about what sensitive information do you collect, how do you use it, and retention periods. Again, this is now effectively the naming and shaming part of the data minimization. They've imposed a data minimization requirement, and now they're requiring companies to disclose their retention periods for certain types of data. And then you've got go ahead, Noga. I thought you were going to jump in there.
Yeah, I'm going to interrupt you because I think the trend there, so again, as we're trying to implement this, the trend still seems to be that companies at this point aren't disclosing specific retention periods. I wonder if they will. We mentioned before this call that potentially the FTC indicated they were looking into this with the Drizzly case. So for now, we're just seeing very general retention periods.
Yeah, I think we will still
think.
see that for a while.
Yeah.
I mean, that was the case in Europe. I mean, Europe has the strict requirements around data minimization and strict requirements about disclosing data retention policies in your privacy notice. But by and large, for the most part, everyone sticks with we may disclose personal information as reasonably necessary to achieve the purposes described above or described below, or as long as we have an employment relationship with you, and then for a time thereafter. And when determining how long to retain it thereafter, we take into account legal compliance, litigation issues, resolving complaints, internal research and record keeping and audit. So there's room to have a broader statement. I would not be surprised if we see a push from the enforcement authorities to get something more granular. The pushback will be, in the US, we have a very strong unfair and deceptive acts and practices legal framework. So companies are going to be loath to say, this is how long we retain this type of data and we delete it thereafter, when there's a host of exceptions that may apply and may give you valid grounds, if not legal requirements, to retain it thereafter. And if you don't live up to what you published, you've now committed a deceptive act and practice, and you may be subject to an FTC investigation, another regulatory investigation, or in some states, a private right of action. So I think that's going to be the pushback that we see against those granular disclosures, but we'll see where things align in the regulations. So far, they're not demanding tables that list everything out, but there will be push for that. But I don't see that becoming the norm for quite some time.
And James, I think it's important to point out with this slide that, for instance, number 6, reasonably accessible data subjects with disabilities. Some of these requirements that we're pointing out are in the proposed regs, which have not been finalized and don't have a timeline to be finalized. Having said that, from my end, from the practical implementation, we're going to treat a lot of the regs as mandatory for now and just start implementing them. And then the other practical advice I would give is that we are creating separate privacy policies and privacy notices. So for instance, we have one for our internal employees on our internal website. Then for job applicants, we have a separate notice on our website. And then we have another notice that we're going to create for I think for now, for former employees, their beneficiaries, things like that. So we're probably ending up with three privacy notices, some public, some more internal.
Yep.
Yeah.
Go ahead, Dave.
James.
Yeah.
I wanted to say that on that point, Noga, it's also, we're talking about notice here, but it just made me think about the CPRA requirements to attempt to avoid dark patterns as well. So probably a good time for all of your outward facing communications with employees and with your consumers, a good time to just look at what you've got on your websites, et cetera, and revamp those. I also wanted to just jump in here quickly because we got a couple great questions from the audience here, and James, probably over to you for these. The first one, with respect to login information, we store passwords in a hashed format. Would that still be seen as sensitive? So good question with regards to how to hash or store separately in secure places. What's your comment on that?
Gotcha. And I will give that normal, horrible legal caveat
Sure.
that not here to provide legal advice, and this is not establishing an attorney-client relationship, all that stuff. However, what I would say, there's nothing expressed in the statute that addresses this. I would imagine that the California regulators, particularly given the GDPR influence, will follow the European style of analysis here. And I think what it ends up being the plain language of the law, if it's personal data, if you've encrypted it or done something else to it, it's still personal data, no matter what you've got inside the box. Like I can put my diamonds inside a box that nobody can break into. I'm still carrying diamonds around. If you've got a fantastic hash, salted hash, encrypted, quantum computing, whatever you've done to it to make it secure, the hashed email address is still going to be personal data, because effectively what it does in most of the environments, it's going to allow you at some point to identify the person. It's probably depending on how it's hashed, depending on how the keys are maintained, likely going to be a good way to get reasonable security in place, but it's security for personal information, and it would be security for sensitive personal information if you had all those login credentials hashed and kept away. But it's not going to create too much of a headache, likely, because you just have to say we collect sensitive information such as login credentials. I don't think too many employees are going to be surprised about that.
Right, right. That makes good sense. And then just one quick follow-up. I'll let you get back to the presentation here. Sensitive personal information is defined as personal info that reveals, in quotes, race or ethnic origin. Photos could reveal race or ethnic origin. Are photos sensitive personal information?
That's a great question. That has been a thorn in the side of many companies for some time in the EU, because it's the same definition. The general approach has been to say photos do not on their own reveal race or ethnicity. That has been the general approach. I can see why somebody would say, well, that seems counterintuitive, because it seems like people use them all the time to infer that. And at least with the UK ICO and others, they have taken the position, although some data protection authorities that are stricter have taken the other view. If you're not using the photos to any way infer it, then it likely is not going to be sensitive personal information. I think in many cases, a lot of employees are collecting race or ethnicity information for diversity purposes. Maybe it's voluntary, but you're going to have it somewhere. So you probably don't lose a lot by saying that, yes, we collect it, but the photos you're not using probably for the things that would trigger the opt-out right, the limit the use right. But I think there are reasonable grounds to say that a photo on its own does not constitute race, ethnicity information or biometrics until you start using it for those purposes.
Terrific. And then just a quick follow-up, and then we'll let you get back to it, is video, voice, similar categories, or a little bit different?
Video, voice. I think video, voice likely is not going to be sensitive. It'll be in that weird category of audio, video, or olfactory data that you collect. Right. I still don't know why olfactory was in there for California, but it would fall under that, is likely the category that you would want to be using, unless you start using voice prints to identify individuals, and then maybe it's a biometric.
Right. Right. Terrific. All right. Thanks.
Did you have anything, Noga, that you wanted to follow up on there?
Nope, we're good to
go. So this is the data minimization and purpose limitation. And I mean, just as the outside counsel, what I can say is there is now this obligation. And so HR, IT, and others in operations need to start thinking about, when you collect the information, do you really need to collect all of that information? It's essentially putting that European view of, stop thinking that more data is better by default, although it often is, but really think about, what data do I really need? What is the purpose of collecting this data? What do I need to achieve it? And how long do I need to have it? As opposed to just having the, tons and tons of files of information about your employees that you're not quite sure what they're there for.
And James, again, this one, I think where it's going to kick in this, in the HR field, is around employee monitoring.
Yep.
What do I need to collect? Why do I need to collect it? Is it disproportionate? Is it reasonable and necessary? So that's, and I think another thing that the audience members should consider that's a little weird for us here in the US is documenting everything. So creating this auditable trail. I'm collecting this information. It's sensitive, but here's why, or, it may seem disproportionate, but here's why it's proportionate. So it's almost creating a paper trail that's very uncomfortable for us here in the US when you think about litigation, but it's important to document why you think it's proportionate and necessary.
Yep.
Next slide, Dave.
And one of the reasons that can motivate some of, at least encouraging some teams to think about data minimization, is the right to access. The right to access is broad. Essentially, an employee or anyone, candidate, former employee, can say, I want to know the categories of personal information you collected about me, where you got it from, what you're doing with it, Whether you sold or shared it, likely not happening in the employment context. But perhaps most problematically, and the specific pieces of information, not just the categories, but the specific pieces. And that would include ways in which you've profiled me, inferences that you've made about me, personnel records potentially. So that can be very broad. You must disclose whatever was collected in the past 12-month period. That's the default. But individuals can ask for it to go further back. However, the most recent date they can ask back to is January 1 of this year. So January 1 of this coming year, employees can ask for all of the data that was collected in the past year. You don't have to go back to 1970. If you've got data from 1970, you might want to think whether there's any reason to really still have it. There may not be. There might be in some cases, but you might want to start getting rid of that. But you wouldn't have to disclose that subject to one of these requests.
And James, this is where I always shout, delete, 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 delete. If you don't have a data retention schedule, create one. Remember, as of now, right of access includes emails or Slack between individuals that are not business related. So, Ampersand is moving ahead with instituting a retention schedule around Slack. We just implemented Slack recently, which is why we don't have a schedule. James, I've heard things like companies having a 9-day schedule, 30-day schedule, 2 years even. We're probably going to lean towards 90 days. But the important thing is we're going out and explaining to our employees why we're doing that. We're doing training. So that I think is really important. And then there is another law in California under the labor code. You could ask for your personnel file. So just know that's out there, and the response period is different for them when you have to respond. So we're creating a Zendesk to manage all these data subject rights, and I'm going to have 2 separate, like we're going to, do you want a data deletion? Do you want data access? So I'm going to have one for under labor code just to make sure I know what they're asking for.
Yeah.
I'm assuming most people are going to come under this law, and that California is going to do a big publicity, news press or something pushing out that they're doing this. That's my guess.
Yeah, I would not be surprised about that. I also think we will see, just like we did in Europe when the GDPR came out.
Yeah.
Employees and their lawyers will use this as a means of pre-litigation discovery to this extent they can. So although you may not get the flood of requests that you might get from consumers, depending on the size of your organization, how many California residents you have, I think you can expect more than just a handful, and some of them may be problematic, but it is worth flagging who's making the request. Are we subject to a dispute with this person? And start thinking about the types of records that you might be able to apply the exceptions to, whether it's arguing trade secrets on certain things, whether it's saying no, that revealing this would adversely impact the rights of some other natural person, whether you're not allowed to disclose it, whether it's subject to privilege and the like. But again, sort of that balance of, if you get rid of the data, you'll never have to disclose it,
Right.
which may make things a lot easier.
James, to that last point, and for both of you, I'm curious, I'm going to guess that a lot of folks out there in the audience who are working in organizations and thinking about how to operationalize the ability to respond to these requests. How do I know how much to disclose on the first pass? Let's say it's a general request. And is there kind of a phased approach, or to just go deep and try to find absolutely everything on that employee that exists in all the systems within the organization is obviously a huge task. So what are some strategies and approaches you might recommend for folks as they're getting started with thinking about how to respond to these requests?
Sure. So under GDPR, what we did was we had a form letter prepared. So one was right away, they got a response. We got your request. We're confirming we got it. Then we had another one that outlined.
Which, by the way, Noga, that satisfies their specific notification requirements that we have received requests written into the law, correct? So you're taking care of that obligation.
Exactly. So that's one thing done, right? Then the next piece was we had a letter prepared and ready to go that outlined to the employees that a lot of times they're actually able to pull the majority of the documents they're requesting, payroll, vacation days, things like that. So we pointed out which systems they could go to. having said that, and James, I'm curious to see what you think. So I actually, Dave, I had a friend that used this, the right of access in Europe to request information from his company because he was having issues with them. So I'm a little nervous, giving a smaller response, like a more limited response, but I am hearing that from other companies that they are doing that. So I'm wondering if the way to go is that first letter being like, here, this is what we have on you so far, sending it out, and either saying we will look further into this or being like, do you need anything else? What are your thoughts?
I think there's a range. I know some companies want to fully automate the process and just be able to say, here's the data dump. And essentially they're going fairly broad then. They may not be diving into all of the unstructured data on the grounds that it's not reasonably accessible and they're not really using it for operational purposes. But if you've got unstructured data from an email, let's say, that's actually sort of worked its way into an evaluation or a personnel record, that would be disclosed. But doing a litigation style doc review for every single time somebody's name is mentioned in the corporate emails, very few companies I know are doing that, particularly if they're of any size. So that's the automated version. Others are taking the view that, look, the enforcement here is mainly going to be driven by complaints. So if you provide people what they're looking for, they're probably not going to complain. So the initial response might be, got your request, we verified that it's you, so we'd like to help you out. Is there specific information that you're looking for? Because we can do a full sale, here's everything, and some employees may want that because they're just mad and they want to get everything.
But maybe they're looking for one specific piece, and you can
they may just be like, look, I'm having issues because somebody said that I didn't do something right with my leave request or something, and that's all I'm really out. Maybe I'm still mad, but I just want to focus on this 3-week period. So I'm just looking for my logins, my time clock entries. And then you provide that to them and you're done. Arguably, they can just say, no, I want everything. Not arguably, I think they absolutely can say, I want everything. And then you've got to be prepared. You're probably not going to find everything, probably not even going to look for everything. Some unstructured data you may leave aside. Some data you might end up saying, look, we have a whole bunch of login credentials, or we have information about every single piece of merchandise you've scanned for inventory, and maybe provide that. And then if they come back and say, no, I want every single scan, then go ahead and hand it over. But I don't think most employees are going to want all of those records.
Makes sense. All right, shall we move on?
Sure thing.
Hey, sorry, one more thing. Sorry,
go for it.
I know there were questions around, I see a couple of friends in the chat. I know there were questions around Slack and data retention. Honestly, that's a whole other webinar, Dave. Have your next webinar set up, but it's complicated. I'll let you go, James.
Yeah. It's complicated. Again, one way to address this, you've got 45 to 90 days to respond to the request. 45 is the default, with an additional 45 if you've got reasonable grounds to delay it, which I think some companies may be taking advantage of, at least in the first half of 2023, while they're getting their processes up and running. But 45 days, if you're retaining stuff for less than 45 days, you may not have to disclose it at all. So that can be an approach. Now, the right to delete, one thing that you'll sometimes hear as well, this right to delete is limited because the way that the statute is written, it says they have the right to delete information collected from the consumer. So if Noga's my employee and Dave gives me information about her, then arguably I don't have to delete it. It's not subject to delete. The statute is vague. I think there are reasonable grounds to say that it's limited to information that you've collected from. The question is whether you really want to rely on that when there's also this broad access right. So, somebody requests a delete and then you provide all this information, and do you really want to respond with, well, the statute says I just have to delete it from? I think that's legally, there's good grounds to argue that. Optically, it may not be the best position. Also, there are so many grounds to retain data based on the exceptions written into the law that you may not have to rely on that as much, but it is something to remember. So I think the exemptions are significant. You don't have to delete anything if you're required by law to retain it, not by contract, but by law. If you're using it just for internal record keeping purposes that are reasonably aligned with the consumer's expectations. So if you've told your employees that you retain data for workforce management, then you can maintain it. Remembering the data minimization, maybe you don't need all of that data. Maybe you just need some of it so you can track how employees have done in the past. And then there's other things like necessary to complete a transaction, security purposes, and again, trade secrets again, so you wouldn't have to delete that type of information. So the exemptions are significant, but I think the data minimization issue is what really might trigger, yes, there's some data that you will have to either anonymize or delete in response to one of these requests.
And
You know,
James, again, this is
go ahead.
where this is where I'm gonna probably spend my next couple of weeks going through this and starting to outline, like, here's the data, what exemption do I have? So for instance, employee monitoring, I could say it's for security. If I have an employee come to me and say, I want all my information, I'm fighting with another employee, I want all the information on your investigation, then I would push back, I'm sorry, I want you to delete that, or I had a bad review that I want you to delete. All of that, that's where I'm going to literally have to sit down in an Excel sheet and start saying no, and this is why. So I have my letter prepared and to be able to respond to these requests.
Yeah, and again, I would say right to delete is about the objective facts. The fact that James rated Noga a certain rating, likely you can't correct. But because that's subjective, like saying that I'm wrong would not be something that you can delete. Whether I was maybe absent on a particular day, or whether, how many deliveries I made on a certain day, that is something that could be subject to correction. It's not an automatic right. You have to go through a process, but if you're going to deny it and say, no, we think that we're right about this, you're going to have to explain why you think you're right.
Another general point I think is probably worth flagging here, both for the right to delete and previously for the right to access. Ron in the question flagged a good thing. Will you be sifting through these messages for non-business related content? I think it brings up an interesting general point with respect to all of these requests that's contingent on the volume, of course, but the ability to have people kind of reviewing and scanning the information before it goes back out to the employee, probably prudent if the volume is relatively low, as opposed to looking for an automated solution, which may seem like it just takes care of things quickly and efficiently, but maybe a little less wise. Comments on that?
I think we're going to be going through things. That's my guess. And Ron, I do think it is like a litigation. And again, I think this is why it's going to get used. The right to delete, the right to access is going to be these angry employees or former employees, or potentially job applicants, somebody that didn't get a job. Why did I not? So we're, again, and we're going to talk about this a little bit later, but I think training is going to be huge. Just making sure that your recruiting department isn't keeping too much, unnecessary information, or keeping it for a shorter period of time. Same with hiring managers. So yeah, I think we have an interesting year ahead of us.
I think it is, I think for any of these rights requests, it's worth confirming that who it is who's submitting it and what they're looking for, and having a review. And just like it's times I've seen even on the consumer side where some request is being escalated and no one's taking the time to figure out, wait, who is this person? And you find out they're a journalist, they're a researcher, they're an enforcement authority. Like, find out who you're dealing with before you just send the information back, or before you have a dismissive response. It's worthwhile thinking about, what's the relationship that I want to have with this person?
James, there was this crazy case in Canada where I think a wife had requested certain information. And the company ended up responding, that it was tied to her husband, and they ended up responding. So they violated the privacy of the husband. So verification, we didn't speak to that, but that's really crucial, especially again with the former employees, not so much with your existing, because you could just send it to their, confirmation via email. You can meet that with them in person, but the former, it makes it a little bit harder.
Absolutely. Interest of time, I want to keep us moving forward.
Yeah. Right to correct. We've talked about this. Again, it applies only to the information after 2022, and you have to give a detailed response. We can talk more about this, but it's fairly, like, a lot of it is going to be fairly common sense. Somebody's going to be able to, for some data, you may be able to say, go use the self-service Workday platform. If you've changed your address, just go in and change it. You may still have to, based on the way the statute is, you can't demand or require that they use the self-service. I think it's fine to point them that way, give them the easy option, let them know that they're not going to have to go through verification. They can do certain things themselves. However, if they say, nope, I want you to do it for me, they likely are going to be able to do that based on the way that the law is written.
And again, right, it's not, if I got a bad review, it's not going to my boss and saying, correct my review. Right.
Yep.
So it's not, you have to look at the totality of the circumstances. That's how they said it, including whether or not it's subjective.
Yep.
So it's, anyway, Dave, in the interest of time, we could move ahead.
Yeah.
So this is going back. Remember that the scope of sensitive information is broad. So this idea that you can limit the use of sensitive personal information sounds rather frightening at first. Like, wait, what does it mean that people get to limit the use of their login credentials or their bank account information that you need to have for payroll? Well, there are broad exceptions. The big one is if you're not using the information to develop inferences about the employees, then the right doesn't apply. It's still sensitive. You still have to call it sensitive, but they don't have a right to limit the use of that information. So for the most part, if you think back to the criteria, most of the sensitive data likely is not being used to create a profile or develop inferences about their characteristics. And I would say the two exceptions might be login credentials by IT if they're trying to assess certain types of behaviors or activities for cybersecurity purposes, maybe, and geolocation maybe for fleet drivers if you're looking at their performance or efficiency, maybe. It may not be. It may still be subject to other exceptions like security and integrity, performing services on behalf of the business. I think the core is most businesses with their HR data are not compiling profiles of their employees for use of monetizing that data, selling that data, targeting those individuals with advertising or some forth. So for the most part, I think limit the use is not going to be applicable in the employment context. But if you are using certain sensitive data to figure out what your employees are like, how good they are, it's worth diving in and seeing whether there really is an arguable exception.
Mm-hmm.
James, I can't think of any situation where this one applies, but.
Correct. So I'll go through this like slightly quickly. Sales, if you remember, if for those of you who've dealt with CCPA before, it's broad. Any disclosure to a third party that isn't limited to their use of information only to provide services back to you, and there's some kind of consideration for it, which could just be free services or the like, that's a sale. Sharing is really disclosing information for targeted advertising. It seems unlikely to me that a company is using employee data for targeted advertising, except when they're a consumer and they're surfing the website, then maybe you are, but that's a different compliance structure. You'll deal with that with your consumer side. And on the sales, most disclosures are going to be directed disclosures, disclosures to commonly branded affiliates, disclosures to service providers, unlikely to be sales. The only things to look at maybe and think about are intragroup transfers. So if you've got a bunch of affiliated companies that don't share common branding and they're sharing data for certain purposes, and maybe it's not just as service providers or processors, may want to see if you can justify that data transfer as not being a sale. I would look at whether there's consideration. There might be arguments there. Maybe certain benefits providers or discount programs or the like, if you're disclosing information to an entity, maybe just making sure that it's either a just directed disclosure the employee wanted it to go there, or that they're a service provider until such point as the employee starts interacting with them. I think those are the things to look at. But for the most part, I don't think you're going to see a right to opt out for the employee data with the disclosures.
And James, real quick, right? So the example, the common or maybe common example is a subsidiary sharing payroll information, for instance, with the parent company who then maintains the payroll. But
Yeah.
I don't think this is one to worry about too much.
Right.
And if there was any question, the safe approach would be to put a data protection agreement in place. Would that be one way to?
We had intra-group data protection agreements in place, correct?
Yep.
Okay.
And there's all of for a lot of companies, they did the vendor agreement work for CCPA with their consumer facing. It's now just expanding that to cover your HR vendors, make sure your service providers have the service provider language in it, maybe update the templates to include the language that's now required under California, things like the service provider must allow the business to reasonably assess compliance with the agreement, that the service provider needs to notify the business if it's no longer able to comply with its obligations, and the business can be able to remediate any unauthorized processing based on that notification. So you may need some tweaks. If you have already have sort of template agreements that are addressing GDPR and CCPA, you're likely a long way there, if not all the way there already, but you may need to look at your templates and your existing agreements on a prioritized risk-based approach and update them as needed to reflect the requirements.
And James, I mentioned before that I actually reached out to my vendors saying to them, I was trying to be nice. Hey, I'll work off your paper, send it to me, and nobody did.
Yeah.
And I think the reason for that is because the regs are not finalized, and most companies, I think, are afraid of redoing their DPAs again.
Yep.
But for now, I'm in a holding pattern. I'll give them another month, and then I'll just start sending out mine.
Yeah, I think I think it was the regs worried about that. Are they going to have new changes? And I think also up until last month, even some people were still holding their breath for the legislature to carve out employee data completely, but
Right.
They just didn't pick it up.
And it may be worth just stopping there for 2 seconds and telling people, like, I'm looking at, okay, it's October, 27th. What do I work on first?
Yep.
Because, and I really do think there are people that have not started because they were relying on that exemption and they thought it was going to go through. Make sure you have a point of contact and person responsible for privacy. In my company, it's me. But then have your privacy champs, right? This idea that my HR department, I've trained them all on CCPA, CPRA. They know this is coming. They know how, how we're going to respond. I will retrain them again just on data subject rights. Doing data inventory mapping, I think, is my next one, because that ties to my privacy notices that I think I need to get up right away. So James, those are my low-hanging fruit. And then it's creating that auditable record. It's mitigating risk, things like that I think are key. But maybe data retention is another one that I'm going to push out quicker and not wait until next year to finish my compliance. But I would say if you haven't started, that's a couple of places where I would definitely get going.
I know when we were preparing for the call, you were mentioning that some of your HR vendors need a little privacy education. Always a good opportunity to bring them up to speed on requirements and obligations for processors and downstream vendors.
Absolutely. And so again, we're definitely doing that training. And Dave, I have to tell you, it was interesting. I got my first DPA, so data protection addendum. And yes, we do use that for HR data. I got it from a vendor who is going to get our employees login information, maybe their contact details, things like that. So they've actually started implementing, but that's the first and only time I've seen it. So we may see those starting to slowly roll in the next couple of months. So that's like another thing just to be prepared for.
Yeah.
And the point of this panel, guys, was a lot of you have probably looked into this, but what are the surprises? The scope of personal information is very broad. So again, go back to that notice slide and look, there's probably things you haven't considered that fall under this law. Look at this sensitive data, login information being falling under that is probably a surprise. James, I don't know if you have anything to add under that number one.
No, I think just push people. I think it's the instant response you will get from a lot of stakeholders is, oh, this is all we collect. But just they'll be thinking of PII, personally identifiable information, instead of personal information. So I think the core training for this right now, both at the employee level and also consumer, is just really training US stakeholders to recognize that personal information is no longer just name and social security number. It's anything that could be linked to you.
And James, just one of the questions we got was whether or not to, include all the states or just California.
Yeah.
And I will speak to this just personally again. I am going to just limit it for now to California. The other state privacy laws didn't include employee data, and I think they didn't include it on purpose.
Correct.
But what I'm going to then have to manage is if somebody from another state comes to me and I say no, that's not a really good look. So that's something I just need to consider, is whether or not to expand this. Maybe again, I'll expand it to limited right. Well, what are you looking for? And just limit it to that information that I'll provide them at that point. Otherwise, I'll probably push back. And that ties into number two, which is, again, it's probably pre-litigation discovery. Again, I had a friend do this, and they did get information because they were fighting their company at that time. Do you want to take number three?
Sure. Yeah. There's no express exception for succession planning. What do I mean here? So you've got your list of information of, once I decide to retire, everyone who's going to be up to take my place or the like, or you're about to have, it's not succession planning, you're about to have a redundancy and you've identified who's going to be first to go and who's going to be retained. And somebody issues an access request. In the UK, the Information Commissioner's Office has issued a whole bunch of exceptions to access. And there's a generally accepted consideration that if you don't have to disclose anything that would hamper your ongoing negotiations with the individual. So I'm trying to negotiate a raise. I'm not going to be able to get the emails that are back and forth where Dave and Noga are discussing why I shouldn't get it. But in the US, we don't have that yet, and we don't have it about redundancy. The one area which I still think is worth exploring, the statute says AG, CPPA issue regulations that define what specific pieces of personal information mean, with an aim of providing individuals with what's relevant while addressing the unnecessary burden on companies, and also addressing the risk of disclosing trade secrets. And some succession planning or financial management or business management information, that would be a trade secret. I think there are very strong arguments that the company derives independent economic value from that information not being known, and they take reasonable steps to secure that data. It would satisfy California trade secret law, so you can maybe withhold it based on that. The challenge is, at the moment, we don't have regulations that expressly say if something is a trade secret, you don't have to disclose it. There may be room to make that argument to the AG or anyone else who's investigating you for an access report that says, we know you have succession plans. Why are they not in my access report? There may be grounds to document that that's why you're withholding it. At the moment, we're still waiting for regulations that expressly address it.
Yeah, we should probably give a quick update on that. I'm guessing a lot of people on the call are aware that the California still owes regulations to provide more specificity and clarity to the law, and the CPPA, the board responsible for publishing those regulations, has gone through a number of drafts. There's a public input period happening. It's supposed to be one just even last week. It just got pushed off, I believe, I think they pushed it off till the first week in November.
Next Friday.
Discuss the latest draft, and then the drafts are available online. You can see the marked up copies with the additions and the subtractions, and but the final regulations are yet to be published, and we are all awaiting those for further guidance. So we are coming to just about the end of our time here. Wanted to thank both of you, James and Noga, for sharing your expertise and time on the panel here. We handled a lot of the questions that came in from the audience. Thank you all for being such a terrific audience out there today. providing us with a lot of great questions and a lot of great back and forth. So there's still some work to be done here for sure. I'm sure we'll be doing another update on this topic, maybe 6 months or a year from now, and we'll maybe have some more settled issues, some published regulations. We can provide some more concrete guidance. But in the meantime, thank you again, James and Noga, for spending some time here. Really appreciate you sharing your time. And if anybody is interested in getting in touch with me or Noga or James, we've got contact information listed here on this slide. And once again, we're going to be sending an email out to the full registration list of this webinar, and including a PDF of these slides and a recording, a link to get to the recording. So with that, thanks everybody. Have a fantastic rest of the day and rest of the week. And we'll see you on the next webinar. Take good care.
Take care, everyone.
Bye-bye.